Hello, good afternoon. It's Wednesday, and we are here again for another session of ALDAV Live. I'm Keith Davidson,
I'm Stuart Albertson.
and we are coming to you from a very rainy San Diego today, and hopefully bringing some issues to your attention that maybe you didn't know before. If you'd like, you can always drop us a question on Facebook or YouTube. We are simulcasting on both of those platforms. So if you have any questions, feel free to drop us a line there. And of course, you can always send us an email if you want to ask us questions in advance to answer. We have had a lot of information and questions coming in, and we're going to hopefully answer some of those questions today. So why don't we start off by looking at the beneficiaries corner. And we have an interesting issue today, and maybe interesting is the wrong term, maybe it's terrifying. Maybe we have a terrifying issue to look at today, and that's the case of Barefoot versus Jennings. So do you want me to go over this one, the fact part of this, Stuart, or do you want to handle
No,
that?
go ahead. That's fine.
All right. So Barefoot versus Jennings is a case that comes out of the 5th Appellate District, and I think it was decided in September or August of this year, so it's a very new case. And it's one that has a lot of us trust and will litigators kind of up in arms a little bit, because traditionally, what would happen is if you're going to file a trust contest, there's a provision of the probate code, section 17200, that we all use and we all refer to when we file a trust contest. And we say that's the procedure, that's the statutory authority for us filing a trust contest. Well, Barefoot said you cannot file under 17200 or use that code section unless you are an actual present beneficiary of the trust under the current iteration of the trust amendments. And so that's a case where there was many amendments to the trust, and the people who sued to contest the trust have been disinherited several amendments ago. So they were beneficiaries under a prior amendment, not a beneficiary under the last amendment prior to death. And then they come in and they want to roll back the amendments. That's a typical trust contest case, is you have some amendments, you want to roll them back. So you contest the last amendment. And the other side objected and said, well, you're not a current beneficiary of the trust, and therefore you cannot bring a trust contest in probate court using probate code section 17200. And I think, to my way of thinking, every trust litigation attorney who heard that argument would say that's ridiculous. Correct?
I agree 100%. When I was first starting to practice years ago, I remember reading 17,000 et sec. That's just a fancy way we lawyers say the whole code provision pertaining to 1700, which encompasses 17200. And I always saw probate code 17200 as the gateway or the pathway into the probate court. It allowed you to say to the probate court, I'm here under 17200. I represent this disinherited heir who used to be a beneficiary of the trust. They're no longer under the current iteration of the trust, but we're asking this court, since it has the authority to look at the way trusts are created or not created, and I want to ask you, court, to invalidate this trust.
Although I think people would say that they are a beneficiary under the current iteration of the trust, in the sense that we don't think that last amendment is valid. So we think we are rightful beneficiaries, right?
Yes, but that's not how this case is going to look at
Right.
it. This case is going to say if you're not listed in a current iteration of the trust, then you're not a beneficiary. You could be an heir, that may be your mom or your dad that created the trust, but if your mom or dad signed the 24th Amendment or the 17th Amendment or whatever it was in this Barefoot case, and you're no longer listed as a beneficiary, you can no longer file a trust contest under probate code 17200, which begs the question, well, what do you file under, or
Right.
where do you file?
Where do you file? And the problem, too, is that in this case, they quote Lins v. Lins. That's a case that we're very familiar with. But they say, look, in this other case, Lins, the parties filed a complaint to contest the trust, not a petition under 17200, and they filed it in probate court. So to my way of thinking, why couldn't that be a way into the probate court? But I think you disagree with that, because you think that, go ahead. Well, you say why you disagree.
Well,
with
I think it's just a semantics problem, because I don't know if this particular appellate court is looking at 17200 as an administrative type statute, or maybe they're just reading it very narrow at the beginning when it says that if you're a beneficiary or trustee, you can bring a claim under 17200. The problem is we've always been able to bring trust contests that we called petitions under 17200. So if it's as simple as simply not citing to 17200, and saying rather than I'm bringing a petition, I'm bringing a quote unquote complaint, it seems to me a little ridiculous because that's a distinction without a difference. All we're doing is changing the name of something, and yet we're still moving forward in the probate court. But the concern I have, Keith, is that if 17200 is no longer available to us, the gateway to the probate court, what do we point to the probate court to say, we have the authority to be here in front of you, probate court, to ask you to invalidate this trust, which leads me to believe that more than likely we're filing trust contests in the civil court now.
So then the civil court becomes your jurisdiction. That's where you're going to go to file a trust contest claim, which is ironic because the only people who are going to have to go to civil court to file a trust contest claim in that scenario is people who are not named in the last amendment or the last version of the trust. But if you're named in the last version of the trust in some way, somehow, as a beneficiary, even if your share is greatly reduced, you still have the power to go under 17200 and file your case in probate court.
Yeah, let me give you an example. Let's say that you and I are brothers, and we're in, there's a trust, and let's say there's 20 amendments to it. And the 20th amendment, your share is cut down by 95%. You go from $1 million to like $5, but you're still a beneficiary of the trust.
Yeah.
I'm your brother. I'm actually disinherited totally. So no longer could we join forces to file a petition or a complaint. I'd be filing a complaint in the civil court with potentially a right to a jury trial, which I want you to talk about, where you found in the statute there you think we have a right to a jury trial now if this is the way we do this. And then you would be relegated to filing under 17200 because you are technically a beneficiary of the trust.
Under the last iteration of the trust, which is funny because if you succeed in overthrowing the amendment and you're named in a prior amendment, then you too are a beneficiary of the trust, but not yet. And because you haven't proven that yet, you can't take advantage of 17200.
And that's interesting. So when we win in the civil court and we become that beneficiary again, do we now file anything we want pertaining to the internal affairs of the trust in the probate court under 17200?
I think you do. I mean, I think at that point you have the legal justification that, yes, it's been adjudicated that I'm a beneficiary. Now I can go into probate court and sue the trustee or whatever it is. I mean, this is the problem with this case is that it raises so many thorny questions that just don't really make a whole lot of sense to practitioners in the field. Right?
Well, and let me ask you, Keith, a personal question. I know when we first were wrestling, we wrestled hard with this case. I saw your gut reaction, but what was your gut reaction to this case? I mean, at first you were a little bit upset at this case.
It just doesn't make any sense. I mean, it does not compute, I think, is the gut reaction. It's like, what are they thinking? And if you were to say that 17200 doesn't allow somebody who's not named in the trust to come in and contest a trust in probate court, then why don't we have some other provision of the probate code that allows that? I mean, that would be the easy fix too, is if the courts don't want to recognize that you can do this, then why not just have a simple amendment to the probate code saying, hey, if you want to contest a trust, this is the forum to do it, because you know as well as I do that civil courts don't want to hear these cases.
Right. And to make this matter even more confusing and ridiculous, in my opinion, if, let's say, we had an 850 petition for a quiet title action, and that's something we could file in the probate court, but we're not a beneficiary of the current amendment, we theoretically still can be in the probate court for that matter, right? But it's still not going to be for a petition under 17200. It's going to be a civil complaint for, I'm guessing, breach of contract. I don't know how we're going to style these, but right now we're in a little bit of limbo. Now, you had heard something about, did the Supreme Court say that they were going to take this up?
I read an article earlier today where they indicated that somebody had indicated that the Supreme Court was going to take this up, or maybe they applied to the Supreme Court and they haven't been denied yet. I hope the Supreme Court takes it up. If they don't, or if the Supreme Court agrees with this decision, then we certainly, I think, are going to need some legislation. But, Probate Code Section 850 is a good example of the only thing that section does, 850, is it allows you to bring a civil lawsuit, essentially a quiet title action to property in the probate court. That's all it does. It doesn't give you a separate legal right of anything. You have to look at the underlying lawsuit. So if you can bring that type of claim in probate court, and the justification for bringing it in probate court is because you have a claim against a trust or a will. So the trust or the estate has assets that belong to you, or the trust or will thinks that you have assets that belong to them. That's what the code says. If you have one of those situations, you can file in in probate court. So if you could do that in probate court, why the heck can't you do a trust contest in probate court, regardless of whether you're named in the document or not?
Well, and not that civil court judges aren't smart and can't understand this stuff, but what are they going to say when all of a sudden they get hit up with all these trust contests? They're going to say, well, the best court for this will be the best judge to hear this is going to be the probate judge because they've dealt with so many trust contests.
Well, and what about how many trust contests right now are filed in courts throughout the state of California? Probably a few 100,000.
Oh, yeah, many.
So now, because of this case, each one of those cases have to be dismissed from probate court. And a lot of them probably are already beyond the statute of limitations. They filed, they were safe because they filed, but now they're going to get dismissed because they filed in the wrong court. I mean, this has tremendous repercussions.
Or maybe not dismissed, but what's going to happen if the probate court cases that you're talking about, all these trust matters, what happens when they get inundated into the civil system all at one time? I mean, how's the civil court system going to handle that?
Yeah, you're going to have some real unhappy judges on the civil side, I think, that didn't intend to be doing trust work, and now they are.
It's almost like family law, which we don't practice, but you've got all these family law cases where people are divorcing one another. It's almost like saying there's a certain subgroup of those people getting a divorce under a certain set of facts that are going to be all of a sudden transferred over to the civil court to handle. I have a feeling that California is going to get this right. Either the Supreme Court's going to get this right, the Judicial Council is going to get it right. Ultimately, the legislature may have to step in to get it right.
And you know, our partner, Gian, a couple years back, was working with a group of attorneys where they were suggesting changes to the law to the Judicial Council. And one of the changes that Gian suggested was changing 17200 to allow these type of lawsuits. And some of the attorneys supported that, but a lot of them didn't. And the reason they didn't is they said, well, everybody knows you can file a trust contest under 17200. It's been happening for decades. Why do we need to change the law now? Well, because of this case now, Barefoot versus Johnson has just proven her very much right and them very much wrong.
Let's do this. I mean, I think we're done talking about Barefoot today, but let's follow up on Barefoot and subsequent episodes here, and we'll find out. Hopefully, somebody will get this fixed. If not, it just. I mean, it's a good thing, right? When has confusion in the law been bad for lawyers? It's been.
Well, yeah.
It's a good day.
It's full employment for lawyers. So
yes.
Thank you, Appellate Court.
Yes.
We should thank them. All right, let's go on to our next segment of Asked and Answered. And so this is the area where we get into questions and answers that we give out a lot. I think there's a lot of confusion in what we do and a lot of confusion in the way the process works and the way you should work with your lawyer. And I think the subject we want to talk to today is trusting your lawyer. And I know that's, I don't know. I mean, I think a lot of people have negative connotations about can they trust their lawyer, right? Lawyers are not to be trusted, are they?
Well, and we do see this from time to time, and it's in a minority of our cases with our clients, and that is there are times when the client just doesn't feel they can trust anyone, including the lawyer. And it makes it difficult in our representation of these folks because they need to trust us. And so if I was a consumer and I was hiring a lawyer, the first thing I'd want to do is I'd either want to talk to them on the phone and get a feeling on the chemistry that I have with them, a gut reaction to their advice. I'm not an idiot. I may not know exactly why I'm calling them or what the law is, but I can tell when somebody knows what they're talking about. Mm-hmm. And get to the point where I can grow in a relationship with them so that when I get to mediation, when I get to arbitration, when I get to trial, whenever that is, and things are moving quickly and my lawyer advises something, I can trust what my lawyer is advising. If I can't get to that type of a relationship, boy, that's a problem. I think either the lawyer, the client, or both need to take a time out, go have lunch together or something so that they can establish a relationship where there's some trust. And I'm not suggesting all this to say that the lawyer's always right or the client has to follow everything that the lawyer suggests, but you can tell. I mean, I'm sure you've been in these cases where this client, you're trying to help them and they won't accept your help because they just don't know how to even begin to trust what you're telling them.
Yeah, it makes it difficult. I mean, I think a majority of our clients do trust us, but we also kind of develop that trust over time and hopefully earn that trust. And I think we try to work with our clients as a team, so we want the client's input and then we give out the advice. But the truth is that there's a lot of tough advice that you have to give clients throughout a case, right? I mean, there's a lot of things that people don't want to hear. There's a lot of gray area, so you can't always say that something is this way or that way. You're not quite sure. And I could see where if somebody, let's say just as friends, let's say every time I tell you a problem, you tell me why I'm wrong and how I need to do the opposite of what my gut tells me to do, at some point there's going to be a breakdown in that relationship, right? And so maybe that's not a good fit. And so I think at some point you have to think about what's a good fit, client and lawyer together. And it's not every lawyer is right for every client and vice versa. So I think you do have to find somebody who's going to be a good fit for you.
Right, right. Well, I think it's important that the communication lines stay open initially in the case. We tend to try to do that the best we can. Of course, as lawyers, we can't spend all day on the phone. On the other hand, you have to communicate with your client. It's required that you communicate with your client under the rules of professional conduct. So communication sometimes can help those things. I think there's just some people, though, that aren't going to trust anybody, and so you do the best you can. I would suggest sitting down and chatting with your lawyer, whether it's by phone, Skype, FaceTime, in person, whatever. Spend some time with them to get to know who they are as a person, and then hopefully when they're giving you advice on transactions that impact you greatly from a monetary standpoint, moving forward, that you can at least rely on that to make an informed decision about which way to move forward in your case.
So what do you think are some good questions that people can ask a lawyer to see if it's going to be a good fit? Because, for example, every now and again you'll get somebody who asks, well, how many cases have you won? You think that's a good question to ask a lawyer?
It's not, because that penalizes lawyers such as us. When we first started practicing, we took every case that we could. That doesn't mean we didn't work hard on it and that we weren't good lawyers, but we took cases that probably didn't have the best fact patterns to them. Even today in our portfolio, I hope none of our opposing counsel are watching, there's probably 10% of our cases that maybe the facts aren't as strong as we would like them to be. And we're seeing if those facts will develop in discovery. But we may lose those cases. And if we lose them, I don't think that should reflect poorly on us as lawyers. Now, if we were lazy and didn't show up to work and didn't care about our work product, care about our clients, care about being great lawyers and doing good work, well, that's a different story.
Maybe that's really what is at the heart of it, is caring, empathy, having some connection to the client. I mean, when you go in and you see a doctor and they're rushing through the appointment and they don't really connect with you and they're not even listening to what you're saying as to what your symptoms are, I mean, that's got to turn you off. I mean, it turns me off. It's not. I don't feel as though that's somebody who really cares or is listening to my problems and giving me good advice.
Are there doctors that don't do that? I mean, I wasn't sure, because that's been my experience with my doctors, especially my urologist. He's very, very quick in and out.
Well, that might be a good thing. Some doctors you want to fast, but yeah, I mean, I think empathy, connection, and maybe that's really what it comes down to. I don't know, but how do you find the right connection? How do you know that you're sitting in front of a lawyer who is the right choice for you? And I think the only way to truly answer that question is to spend some time and go over, have a conversation.
Well, I'd like to suggest that we both used a car salesman a few years ago to purchase cars. And his name is Larry. I don't remember his last name, but Larry, we think highly of you. It was the one time that I used a car salesman, and you told me the same thing, where I felt he gave me a fair deal. I don't know that he did, but I felt that way. And I really felt that he was asking me what my goals were on the car. What did I want? When he went out looking for the car, he searched diligently for it. He brought it up. He went through after I purchased the car, he spent an hour and a half, 2 hours going over the car with me. I mean, who does that? So it was, for me, I felt very good about that transaction. It cost me money. I'm sure I paid for his monthly salary to some degree, right? That's fine. That's what he's there for. But I didn't have that feeling I normally get when I go and buy a car. And it could be that was just us taking the time to sit down and get to know him as an individual, realizing that he actually liked cars. He liked to talk cars. He enjoyed selling cars. And it worked for me, even though I knew that I was paying him for that service.
Right, yeah. I remember reading a business book once that said that you should never hire anybody you don't trust, but once you hire somebody, you should trust them. And that might be true of lawyers too. I mean, if you don't trust somebody, if you get a bad gut reaction, just don't hire them. But once you do hire them, you're going to have to put some trust into your lawyer, because otherwise the relationship doesn't work very well. Because there's going to be a lot of tough discussions in every case. I mean, I can't think of any case that doesn't have its moments when you have to give some tough advice out to the client.
That's right.
All right. let's go on to our next segment, the practice pointers. So this is a section where we like to give out our view on practicing. Practicing law is never an easy thing, and we're always learning new things, I think. And what new thing can you bring to us today, Stuart?
Well, when you run a practice like ours, it starts to get a little overwhelming at times. There's multiple hearing dates, multiple motion dates. There's discovery that we send out, discovery that's supposed to be due us, discovery that we're supposed to respond to. There's phone calls that we have to make. There's emails we have to do. There's pleadings we have to draft. And this is on multiple cases that all have different strategies. And each one of these strategies, it's not cookie cutter. Each case takes its own set of inputs. So I've come across an app, and I normally wouldn't publicize an app, but it's called OmniFocus 3, OMNIFOCUS 3, the number. And it's a Get Things Done app, a GTD app. And it has transformed my ability to see my cases at that 30,000 foot level. And so when I'm meeting with the lawyers in the firm on the cases we're working on, it's so easy to manipulate the data that's in front of me, from hearing dates to discovery due dates to action items to things I'm waiting for. And it's all in one app. It's been fantastic. I think that I could probably increase my capacity by 75% with this particular app. And so it's helped me tremendously, and I would highly recommend. I think they give a 15-day free offer to do this. And by the way, I've incorporated it into my personal life as well, so that if I've got to go to the grocery store, and there's certain, because once I go to the grocery store, I just start going up and down the aisles and start buying everything.
Right.
And then I get home and I find out I've already got that stuff.
Yeah.
But here, if I need something specifically, if I need to run by the dry cleaners, if somebody runs by your office real quickly and says, hey, we need to do this, you can just jump off what you're working on briefly to put it in the inbox and know that you got to come back and address it later. So I don't know. I don't think it's for everybody, but if you have a complex set of scheduling and issues to keep track of, and you have things that you have to get done, OmniFocus 3 is a great way to get started.
Great thing about these apps nowadays is that doesn't that app go on all your different devices? So you can have it on your laptop, your desktop, your phone.
That's right. So your database is stored in the cloud, and it's across every single device you have. So if you make a change on your iPhone, it changes on your desktop, and it's great. That way, there's nothing ever missed. And if you change some dates at home at night on your laptop while you're watching TV or watching a game or something, tomorrow morning when you get in, everything else is going to be up to date.
Yeah, and this isn't a paid endorsement for OmniFocus, although we're certainly open to that if they'd like to contact us. But what is the problem? I mean, when you're running a law practice, what do you think is the biggest problem to try and stay organized with? What's the thing that scares you the most?
Well, running a statute of limitations, to me, I lose sleep over that. That's my reoccurring dream, that I'm a day late on filing something. So statute of limitations, you can keep track of those in OmniFocus, and you even have reminders to remind you of them. I don't know. That traumatizes me more, because now I see them as the time is going down. On the other hand, I'm seeing them and I'm aware of them, rather than there's many times lawyers will be happy sitting in their chair and there goes the statute, right?
Right.
And so statute of limitations, hearing dates are important. Judges like you to make it to the hearing dates when they have them set.
Yeah, they get a little upset when you're not there.
I've missed 3 hearings in my career. I'm hoping that number stays at 3, but it's always embarrassing when you miss a hearing.
Yeah.
And I beat myself up so badly.
Yeah.
But I don't know. Same question to you. What scares you most about running the practice? You're the managing partner of Albertson and Davidson. What are the things that keep you up at night?
Well, certainly the statute of limitations. I mean, that's, we've never missed a statute, and that's something you just do not want to do. You cannot miss a statute of limitations. That's a biggie. I think I think hearings, yes. Although, I think we have cross calendaring for that, so that doesn't worry me as much. But mainly it's all just, there's so many deadlines in litigation, all the discovery deadlines. And so, you have to respond by this date, and the other side has to respond by that date. And then after the other side responds, you have so many days to file a motion to compel if you need more. And if you don't file it, then you can never file it. And so I think what concerns me the most is just the volume of dates that we have to keep track of. There's just so many of them. And so I think having some organized system is huge. And I mean, I think that's why you've been so effective with OmniFocus, and I've started to use it. I haven't used it as much as you have, but I think it at least gives you a starting point to be able to double check all that stuff. I do think it's important though for any attorneys out there, if you're getting your own practice started or you're having issues with your practice, you have some sort of a double check system. So it's great that you have OmniFocus, and you should be looking at it. And then your assistants or paralegals should have some system that they're looking at. And if they use OmniFocus 2, hey, great, whatever works.
Maybe OmniFocus 3, not 2.
If they use it also.
There you go.
They use it also.
All right, words matter, as I
Yeah,
say.
right, they do. So, I mean, I think it's just keeping track of all the various pieces. It can be a lot and it can be overwhelming. But I think nowadays with the technology we have, it can be hugely simplified if you just stay on top of it. Of course, the downside with any system, it doesn't matter if it's OmniFocus or whatever it is you have to do the inputs, you have to take time to put in the information, and then you have to double check it.
That's right, but there's no other way. I mean, you cannot survive with all of those dates floating out there. It doesn't matter how bright you are, you cannot survive. That's why, not to change subjects, but that's why when we're taking a trustee's deposition who has not made good investments with a multi-million-dollar trust portfolio, we can ask them, what process did you have in place for doing this? And if they didn't have a process in place, we asked them, did you write it down? And 99 times out of 100, no, we just did it out of the top of our head. Well, I'm not sure how you do that with such a complex set of inputs to make sure that you're doing your job as a trustee and managing a portfolio of multi-millions of dollars. Same thing with managing cases. You have to have some way of keeping track of everything that is easy to manipulate and see so that you can work at 30,000 feet. But if you need to, you can drop down to 1,000 feet and do something specifically on the case as well.
Yeah, organization. Who knew? All right, let's go on to our last segment. This is our closing argument. So we've been taking on a lot of depositions lately. I mean, we always seem to take a lot of depositions, but recently we've had a lot of really interesting depositions per se. And one of them was a deposition that you took. And why don't you tell us a little bit about it, because it's kind of interesting.
Well, they tell you in law school that the Perry Mason moments are over, right?
Yeah.
You don't,
Very rare.
Everybody knows everything, and with discovery, you get all the documents, and you see all the emails and texts between people.
Yeah.
So there's usually not much of and plus depositions, you're really, as young lawyers out there, if I had one piece of advice, you're not in a deposition to prove your case. You're in a deposition to get information. Now, that information may prove your case, but you're not there to argue with the witness. You're not there to slam dunk the witness. You're not there to, wax eloquent about, whatever it is you plan on doing in your closing statement. And so generally we go into depositions just making sure that we've dotted our I's, crossed our T's. We've seen the universe of documents and texts and emails. But every once in a while you get a fun experience where we get to use our skills as lawyers. And in this case, there was a woman that was from South America, and she spoke Spanish. She also spoke English, but she spoke Spanish. That was her native language, or her first language. And the case involved a family where Italian was primarily spoke by the younger generation of that family. But the older generation of that family spoke it's not really a dialect, it's a subset of its own language called Calabrese. It's Italian with a heavy Greek influence. And it's very difficult for Italians that would speak standard Italian or Italian you would hear in Rome. They have a hard time talking to people that speak Calabrese and vice versa.
I've never even heard of that before. That's really interesting.
So the witness in this case, lady from South America, first language, Spanish, and her English was quite good. She had an accent, but her English was quite good. But the whole case came down to what she had heard a very elderly member of the Italian family say about where she wanted her assets to go when she died. And when the opposing counsel was taking this person's deposition, this lady from South America, he spent a lot of time talking to her about the things that this elderly Italian lady had said to her. And this Spanish lady gave very detailed explanations of their conversations. And I'm sitting there, and it just kind of hits me as this is going on. I've got my outline in front of me that doesn't have any of this in there, but it just kind of hits me that I don't think they could have talked that well. I remember when I was the memory actually I had jog in my mind was when I was at Georgetown University getting my master's in tax law. I hung out with a group that was from South America, Mexico, Spain, Portugal, and I remember when we would go out to go out to drinks or whatever and have a good time. They would all laugh at each other constantly because they couldn't connect on the language, especially the European Spanish speakers and the South American Spanish speakers. It just didn't connect.
It was just different.
It was different, yeah.
Well, and so far, you said that the witness spoke Spanish and English. So where does the Italian come in for her?
Well, and that's where I finally sat down and said, hey, where did you learn to speak Italian? Well, first asked her, what's your first language? Well, Spanish, okay. And what's your second language? English, okay. And where did you learn to speak Italian? And she said she learned from a next door neighbor in the South American country where she had grown up. And so I asked her, I said, how did you learn from that neighbor? Well, I used to go to their house. Okay, well, did you take formal lessons from them? Oh, no, just conversational. Okay. How long did you go to their house? 5 years. Okay. How often did you go to their house? Every day. And I said, okay, let me get this straight. You went to a neighbor's house every single day for 5 years and learned to speak Italian? Well, she backed off of that. So then she said she came to the States later on as she got older, and she took a semester Italian in college because she was taking a trip to Italy or to Rome with her family members. And so I asked her, if she had taken formal training for that. She said, oh yeah, it was a semester. And so I'd asked her if she had learned any of the other forms of Italian or dialects of Italian, and she said no, she hadn't. And so then I asked her, I said, now you had testified that the lady who spoke this Calabrese, and of course I haven't identified Calabrese yet, but the old lady that passed away, you said that she told you all of these specific details about what she wanted done with her assets. Just go ahead and tell me exactly how she told that to you. And you saw her freeze. I mean, you saw this look come over her face. And so then she says in the best Spanish I've ever heard exactly what the lady was supposed to say. The only thing that was funny about it, well, there was many things funny about this, but the thing that was funny was there was about 20 people in the room for the deposition, and all of them were Italian speakers, and they all started laughing. Well, you know how that is in a deposition, right?
Yeah, so they knew that she was speaking Spanish, not Italian.
Yes. And so then I asked her,
Did she speak Calabrese?
So then I asked her if she was aware of any different types of speaking of Italian in Italy. She wasn't. I asked her if the decedent in this case, what type of Italian did she speak? She wasn't sure.
No clue.
She said it was normal Italian. It was perfectly clear to her. And then I asked her about Calabrese. She didn't know what that was. And I asked her if she'd be surprised to learn that that's the language this lady spoke, which again is, as I read it and understand it, it's not a dialect, but it's got a heavy Greek influence. And so it's a language that stands on its own.
And so the decedent didn't speak regular Italian at all. She only spoke Calabrese.
Right, not standard Italian, not the Italian you would hear in Rome. And in fact, her family, her children had told me that they sometimes had a hard time understanding her. So that lets you know that this Calabrese it's a unique, and there's not a whole lot of people that speak it. And so you don't get those moments often in deposition, and I want to ask you if you have any of those moments yourself, but you don't get those moments often, and so when they come along, it's very satisfying. And got a call from the lawyer the next day, and of course they want to go to mediation. So,
well, I guess my question to you though was, did you know this heading into the deposition?
a little bit. I mean, like I knew this was an issue, and I think I may have had it in my notes, but to me it really didn't crystallize until I sat there and listened to the opposing counsel ask question after question about what the decedent in this case told in detail to this lady. And I'm sitting here thinking, this lady is being asked in English these questions, which is her second language, although she speaks fine English, but she's Spanish. She's saying Italian. She said to me in Italian over and over again, and I'm thinking, but this lady didn't speak Italian. She spoke Calabrese.
And going into the deposition, did you know that the witness did or did not speak Calabrese? Speak.
I knew. I was 99.9% certain when I started my questions that she did not know Calabrese.
So it's more of a gut reaction. You're hearing all these detailed facts coming out that she supposedly heard this decedent say, and it just didn't add up in your mind.
Correct.
I mean, that's really the key, isn't it, to taking depositions, is like paying attention?
It is.
I mean,
Well,
it's funny. And that sounds so simple to say, and I'm not making fun of or light of your experience, but that shows your experience, I think, right? Is that like how many young attorneys or any attorneys for that matter, they only have to be young, have a hard time just paying attention in deposition.
well, and I would say this to not only young attorneys, but any attorneys that are going into litigation and learning about depositions or trial for that matter. Judges will tell you this, and other lawyers, opposing lawyers will tell you this after the case is over. When you walk in with your outline and it's written out word for word and you're just sitting there making sure you get all of your questions asked, that is a terrible way to take a deposition. The best way to take a deposition is to put 10 bullet points, and those are the 10 categories of questions you're going to ask, and then act like you're on a first date. Have you ever been on a first date? I mean, when you went on a first date with your wife, I know that you're a little socially backwards and so forth, but you asked her questions, right?
I don't remember. It's too long ago.
You didn't just sit there and stare at her.
I may have.
No, you
Yeah,
asked her
I may have.
questions. And we do that. Think about the uncomfortable silence that happens on a first date.
Yeah.
And so to break that uncomfortableness, what do? You get somebody talking about themselves, you ask them questions. That's what a deposition is. And you're doing it based upon the 10 categories of questions you need to ask. And you may ask those 10 categories, you may be on one category for 20 minutes asking questions in different ways, but then listening to what the deponent is saying so that you can follow up on some of those things.
The other issue that this deposition brings to my mind, so one is, okay, you got to pay attention in depositions, otherwise you're never going to be able to hit pay dirt like you did there. Secondly, what's up with the deposition prep of this witness? I mean, how do you prepare a witness for a deposition like this? Obviously, maybe she had no preparation for this particular deposition, but how do you prepare a witness for
Well, you tell us, how do 99% of attorneys prepare their client for their deposition?
that? Well, 5 minutes before they walk into the room, they say, okay, don't say too much, answer the question, let me object, okay, let's go, right? It's very, very minimal, I would say, most of the time. And it's unfortunate because there's a lot to know heading into a deposition. And I think in a case like this, there'd be a lot for the person, not that you're going to tell the witness to lie, but I think that there at least would have been some value in telling the witness, now wait, I mean, just probing the witness yourself before they walk in and are slaughtered at a deposition, saying, are you sure she told you all of that in that level of detail? How did you speak with her? Finding these things out, because if it's a friendly witness, you can ask all those questions before you actually arrive at deposition.
Well, and that's the other thing that the opposing lawyer could have done during the deposition, right? Is when you hear that and it sounds too good to be true, it generally is.
Right.
So it's better coming from you than from me.
Tell on yourself.
Yeah, tell on yourself. You know, say, you know, you gave me some great detail there. Did she tell that to you specifically in that detail? Because it's my understanding, ma'am, that she spoke Calabrese. Did you speak Calabrese? And there you're asking questions and educating the client at the same, or the witness at the same time. Not that we want witnesses to lie, but there is an art to asking questions so that you're getting the answers that are beneficial to your side.
Although this might have been a case where if they prepared the witness, she actually, she could have been taught, don't embellish whatever it is that happened. It sounded like this witness was trying to kind of embellish, like maybe she was going beyond the truth a little bit, not intentionally trying to lie or mislead, but probably just trying to really drive the point home. And it didn't do her any favors. It actually worked against her.
Right. I to shift gears here just briefly because we have a few minutes left. I remember one time you were taking an attorney's deposition. And again, if you hadn't been listening closely, you wouldn't have had the ability to do what you did. And it had to do with the way this attorney did things, her process, her procedure, and it mattered to the case. And she answered 2 or 3 times in a row to your question that her preference was to do it this way. Tell us about that.
Yeah, and that's exactly like, why did you prepare the deed in a certain way? And she's like, well, my preference is to do this or to do that. And after her answering that a couple times, it dawned on me that, well, that's fine that that's your preference, but I'm not asking you about preferences. I'm asking you why you did it this way in this particular case. And so my preference is to always do everything properly too, but every now and again we make mistakes. So that's what I'm asking you about, the mistakes, not your preference. And it was kind of a sneaky way to try and avoid the question, I think.
Well, and I was at that deposition and I was watching you, and I want to say, again, that sounds like once you hear that, somebody's going to go, well, of course you would follow up with that. But there's a lot of lawyers that they're so busy with their face and their outline
Right.
that they're not listening to that response. And so you stopped the lady and you clarified, and you can see how uncomfortable she was
Right.
once you made her actually testify about what she did, not what she preferred to do.
And I think it takes a certain amount of curiosity, right? So, I mean, I've had depositions before where I just ask a question just because I'm kind of curious. Like in your example, it's like something doesn't add up. Like, well, why did you do that? I don't know. I'm just kind of curious. Why would somebody do this instead of that? Those type of questions can really pay off because, sometimes they don't. Sometimes they'll give you an answer and it's not particularly useful or interesting. But every now and again, you'll ask a question like, why did you do this? I had one deposition where I asked somebody, well, why did you, it was a contract suit and they had overtime charges on the lawsuit, but the overtime charges weren't on the invoices back when the work was originally invoiced. And so, well, that seems odd. Why did you add overtime here? And the witness says, well, I'm just trying to juice up the damages so I can get more. Well, okay. I mean, I didn't expect that answer, but if I hadn't have been curious about, well, why did you do that? Then I probably wouldn't have ever got that answer. But once I got that answer, then I started to ask about every invoice. Well, did you do that on this invoice? And then, of course, he had to say yes because he already backed himself in the
That's a
corner.
brutal afternoon to have to answer that way over and over again.
Yeah.
It got me thinking just talking about this. Next week or whenever we do another one of these, I think we should talk about depositions and how we approach depositions, because I think we've done enough of them. We've made so many mistakes that every mistake under the sun we've made at least
Yeah.
twice in deposition. And so maybe we can give some practice pointers, at least from our viewpoint of how to take an effective deposition.
Yeah, I think that'd be a great idea. Well, that's all we have for you today. Thank you so much for joining us. You can find a recorded version of this on our YouTube channel along with all of our other videos. If you have any other questions that you'd like us to answer, feel free to give me an email. Send me an email, keith@aldavlaw.com, or you can always email Stewart, 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 @aldavlaw.com. And we will be back here next Wednesday, 1:30 p.m. to talk to you again. Thank you.
All right. Take care.